Hi, everyone. Welcome to Court Chatter Live. We're excited to be back. It's been a couple of months since our last show. I'm really excited tonight. We are doing a Q&A on the Ross Harris trial, otherwise known as the hot car death trial. I'm not going to go into a lot of background about the case because we're going to do tonight's show with the assumption that the people that are watching it know about this case, and we really just want to answer your questions that you have. We are, I don't know, maybe halfway through the trial. The state should be getting to rest here in the next couple of days. They'll be getting ready to rest their case, and the defense should start next week, I believe. Ross Harris in June of 2014 forgot or intentionally left his 2-year-old son Cooper in the car, and he died on a hot Georgia day. And that's what this case is about. And he's charged with malice murder. He's also charged with felony murder, and we're going to talk about those charges because people are a little bit confused about them. And he's charged with some sexting with minor charges that they've combined all in this trial. I'm really excited about our guest tonight. So my friend, Phil Holloway, is going to be on here with me, and he's the guy. He's your legal eagle. He's the guy that's going to answer all of your legal questions when it comes to this trial. And I am going to pull him up right now and welcome him there. Hi, Phil.
Hi, everyone.
Okay, Phil, this is the first thing is I had several of our chatters at Court Chatter want to know your background. Not everyone is familiar with you, although they should be. And I'm just going to quickly say, you know, he is a CNN legal analyst. So you should have seen, and he talks about everything from politics to whatever, not just this case. So he's on CNN, HLN a lot. And then he's also 11 Alive there in Atlanta's legal analyst. So he, you should see him on TV a lot. Okay, Phil, give us a rundown of your careers, because you've had a few, and how they relate to the law.
Well, good evening. And as people were asking about this, I was actually in your chat room the last couple of days as people were asking about this. I really don't know why they're so fascinated with my background. I'll probably just work backwards. I'm currently in private practice in Marietta, Georgia, Cobb County, where, of course, the Ross Harris case originated. At the time of Ross Harris's arrest and Cooper's death, I actually lived within a half a mile, quarter of a mile where all this sort of stuff took place. Before going into private practice in 2003, I was a prosecutor, an assistant DA in Cobb County, Georgia. For the majority of the time I was there, I was assigned as a prosecutor to Judge Mary Staley, who is now Mary Staley Clark. So I know her quite well. Had plenty of trial experience with Judge Staley, not only as a prosecutor, but as defense counsel as well. I consider every lawyer involved in this case to be a friend of mine. I consider Judge Staley to be a friend of mine as well. So I feel like I know the personalities of the players. The only one I don't know in the courtroom really is the defendant, Justin Ross Harris. I've never met him in my life. Prior to that, I was in the military as a Navy JAG lawyer. Before that, I was in law school, working backwards. Before law school, I was a police officer. I started out in law enforcement when I was 18 years old. I was not even old enough to purchase the gun that I was issued to carry when I was 18. But things are different now. That was a long time ago. But that's the Reader's Digest version of where I am today.
Okay, well, so as you can see, Phil has every credential you could possibly need in someone we want to talk to about this case. I am so grateful that he has been spending time in our chat room during this trial almost every day, and it's been a great source. So if you have not come to check out the chat room at Court Chatter, do that. You can watch the live stream of the trial, and off to the side is a chat box, and we just chat in real time. And Phil has been joining us while we watch the Justin Ross Harris trial.
I would like to say, if I'm looking away, I'm not ignoring anyone. I'm also tweeting and doing some other social media things myself here and looking up reference materials that I have related to the trial.
Good, perfect. And I control who's on screen. Unfortunately, the way they have this set up on YouTube, I can't put us both on screen at the same time. So I will be flipping us back and forth, and I'm also be reading your questions. If you're watching us live right now, there'll be a chat box off to your right-hand side on YouTube, and you can put your questions for Phil or me into that box, and my moderators are shooting those off to me. If you watch this later in our archives, if you watch the entire show and didn't get something answered, you can make a comment below this video, or you can always pop into Court Chatter and ask. Okay, I say we get started on questions because that's what this is all about, and I have a bunch for you. So I'm going to start with, let's see, I'll poll Grammy Sue. Grammy Sue is from our chat room, and I'm starting with this question because I'll sort of work backwards too, because this was just in the last day or two. Detective Stoddard, who's the lead detective in this case, has been on the stand, and that's kind of the testimony that a lot of us have been waiting for. And Grammy asks, why did the defense ask Detective Stoddard if Leanna Harris was a suspect? And they spent a lot of time on what the police had thought about Leanna Harris and her role in this. And it says, if the defense puts her on the stand, would they try and put some of the blame on her? So, Phil, what do you think about that?
Well, there's a lot there in that question, a lot of questions within the question. But, and I don't presume to know what either side's trial strategy is. I just know what I see, and I know what I might do as a prosecutor or defense counsel. And I wanted to start out by saying I'm not taking any sides in this. I might play devil's advocate as we talk tonight, but that doesn't mean I'm endorsing a position either way. As to the questioning of Stoddard about whether or not Leanna was a suspect, Leanna was mentioned and listed in the police reports as a suspect. And it's obvious by now that one of the main reasons that Mr. Harris was charged the way that he was charged with murder, particularly malice murder and felony murder, is because in the estimation of law enforcement, he was not acting the way someone might be expected to normally act.
Just let me interrupt really quick, and I'll just tell you that for the viewers, you can't see this. I put up the picture of Ross, Leanna, and Cooper when he was a baby. Okay, go ahead. Right.
I can actually see that in the corner of my monitor. But so if you remember the videos that we saw in the last several days in the trial, we saw the Harrises together at police headquarters, and they were acting very differently. And so if I were to presume to guess, the defense is showing, look, Ross Harris is acting one way. So he's a suspect. But Leanna Harris acting the opposite, yet she's still a suspect. So I think that where the defense was going with that was attempting to show the jury that no matter how you act, the Cobb Police Department is going to believe that you are not acting right. That was sort of my takeaway from it. I'm not suggesting that that's what the evidence necessarily proved or what the jury thinks, but I think that might be where the defense is going with it.
Okay, and yeah, and what I would say about that is, I thought that because what they kind of got at the end was, but so you were wrong about Leanna Harris.
Right.
You thought she was a suspect, and they ended with, but you were wrong about that. So that just put some more doubt into the investigation in this, and maybe you're wrong about my client as well. So that's kind of how
I wanted to emphasize, and I think there was some questioning about this. They wanted to emphasize that the point the defense was trying to make was, hey, the police department is really trying their best to make this thing into a conspiracy. The idea is that a good investigator will be objective. They will take the evidence as it is, good, bad, or whatever, and follow it objectively to the truth, wherever that truth may lead. Oftentimes, and I've seen this when I was a prosecutor, I've seen it when I was a police officer, I've seen it as a defense attorney. Sometimes investigators will prejudge a case and form an early opinion, and they will sort of inadvertently or even maybe on purpose, God forbid, steer an investigation in a certain way because it's the way they want it to go. So that's the big part of the defense theme, and they believe that's what Stoddard has done here. I don't know that they've accused him of purposely doing it, but they've accused him at least of subconsciously deciding early on that this was one way and only one way, and that everything else that he did was designed to further that preformed opinion.
That's right. Okay. What letter grade do you give each side as of maybe today?
Well, listen, and I'm not saying this just because I know all these folks, but I think both sides of this case are extremely well represented. And while I can perhaps pick on some style things that I've seen from either side that I might do differently, just like I can critique any lawyer, and I'm sure they can critique me. I've tried cases with or against almost every lawyer involved in this case, and I can tell you they're all doing a fantastic job. So I'm going to have to give them all an A at this point.
I agree. I think both sides have fantastic lawyers. People that think Harris is guilty as guilty can be and are pro-prosecution do not like the defense team. But I think that they might be a little skewed by their opinion of the defendant.
Well,
and,
I can tell you,
and maybe defense attorneys in general, because trial watchers tend to not be huge fans of defense attorneys.
Well, and being a defense attorney myself, I can tell you that sometimes people don't like us until they need us. But if you think about it, what my job and any defense attorney's job is to make sure that if there's a trial, that it's done fairly and that the defendant gets a fair trial, because the last thing that anybody wants is to have a conviction of somebody who may be truly guilty reversed because they had ineffective assistance of counsel. So really, prosecutors want good defense lawyers on the other side. I promise you that.
Okay. This is something that I don't think I have ever heard, but was, were the defense ever offered a plea deal? Were there ever any talks about a plea deal?
If they did such a thing, I haven't heard of it, and I think I would have. My ear is pretty close to the ground on how things are going in the Cobb County judicial campus, and I haven't heard anything about a plea deal or any discussions. And I think that's probably because both sides staked out very much different positions on this from the very beginning, and there seemed to be this real clash. Each side believed that they were 150% correct, and I think probably they still do, which is very unusual, and that's one of the most unusual things about the periphery of this case. I mean, when I talk to my colleagues in prosecution or in the defense world, privately they'll say, okay, we're getting ready to try this case, and you'll know whether or not they privately believe they're going to win or what their chances are of winning or if they have a viable defense. And basically what it seems like in this case is both sides have been 150% committed to the fact that they are right. And so that may have something to do with it. I don't think he's been offered any plea deals. I think we might have heard about it because Judge Staley happens to have one of her typical things that she will do in any case is to discuss before there's a trial in open court on the record with the defendant if there's been any plea deals that are made, and that way she can know and the record can be clear if there's been anything that was not conveyed to the defendant that the defendant might want to know about before deciding to go to trial. So I haven't heard that at all. So I don't think there was a plea deal. Okay,
interesting. So they were never interested in playing him down at all.
And if those discussions happened, it was done very secretly and behind closed doors. There's been nothing mentioned publicly or privately about that.
I would think you would know. You have your ear in this. Okay, I want to talk about Leanna Harris. When this first happened, people thought she was involved, and I guess involved means both her and Ross no longer wanted to be parents, and they conspired to kill him in this horrible, awful manner. I think it's ridiculous, but because of her behavior and some of the things she was quoted as saying, which, by the way, that has not come out in trial yet, that it made her look like she wasn't acting appropriately, or how mothers, you would think a mother would act, that kind of thing. So Leanna Harris, we briefly talked about how Detective Stoddard was asking about her being a suspect, and he says she's not a suspect. Although someone in the chat room, Linda, said she's still a person of interest. I don't know. I don't know if that's ever going to go anywhere, but
he kind of left the door cracked just a little bit on that, as if, to say if something were to ever materialize, then, but he 98% closed that door.
Yeah, right. Okay, so excuse me. We heard some things in the probable cause hearing in 2014 about comments that Leanna had made. And one of them was that when she had arrived at the daycare, she'd not known yet what had happened. And she'd arrived at the daycare that day, that she said, she said to the daycare worker, Ross must have left him in the car. So if that happened and in that way, then yes, like why would that be her first thought? However, the daycare workers have testified and nobody has testified to that. We heard that from Detective Stoddard in 2014 at the probable cause hearing. He testified that she told the daycare worker that. So far, that's not been in this trial. So that's one thing trial watchers think that she's suspicious on. Secondly, go ahead.
If I pardon the interruption, and you're right, it hasn't come out yet. But then again, that would be something that would be hearsay, and it might be appropriate to wait if that evidence exists. It might be appropriate to wait until Leanna testifies, and I think she will. And we don't know that we've heard from all the daycare workers. It's possible that there's others out there. It seems that they have moved on from the daycare workers, but we saw something today, for example, that I didn't expect, which was a witness testifying for the second time in the state's case in chief. So there's more to come. I know that there's more witnesses. I don't know who they are. But what Leanna said, if anything, it might be more appropriate to wait until she's testified. There's been some names that I've heard mentioned in the trial as other people that were working at the daycare that may have encountered her that day, and we haven't heard from some of those folks. So I'm going to just sort of leave that out here as a maybe. We might hear something about it. We might not. I don't know. It would be fascinating to find out exactly what, if anything, she said when she first learned about the tragedy with Cooper.
Well, I will say that I went back and looked at the daycare workers' testimony. I first went back to the 2014 probable cause hearing. We have that on video, and listened to what Detective Stoddard said about that. And he named the person at the daycare that she ran into. Now, at the very moment, I don't have that name, but at the time, I then went into that witness. She has testified in this trial, and that wasn't brought up. But you're right. Maybe when Leanna gets on the stand.
They talked about what her reaction was. They didn't talk about what she said.
Right, and
at least that's my recollection of it.
No, it's true. It's true. And the only thing that daycare worker said was that she was like distraught, and I can't remember the exact words. So far, that's all we've heard about that. Okay, so Leanna gets to the police station, and this is what we have all witnessed this last week, is Ross's police interview. So he's in the interrogation room, and that's always video. There's always a camera going. And after they question him, and we can go back and talk about that later, but after they question him, they let Leanna come in, and this is the first time they're seeing each other. And there's so much talk about this, about how the two of them acted so weird. I don't even know what the word is for the two of them. He all of a sudden became completely, totally hysterical, which he had never been hysterical like that the whole time with the police before. And then she was not hysterical at all. And she is, we're going to get through this, and everything's going to be okay. And I love you, and I don't blame you, and we're going to get through this. And we, I. That was the whole thing. No one said Cooper's name. Sometimes they said, the little guy or little buddy. They said the strangest things. And I'm going to put you up and let you talk about that. And I'm going to grab a picture of them in the interrogation room.
Well,
what are your thoughts?
All right. My thoughts on the interrogation are this. I don't know how someone is supposed to act in that tragedy. If this is actually a true action, a tragedy, if someone loses a loved one like that, I don't know how somebody is supposed to act. I don't know these people. I don't know Ross Harris or Leanna Harris. I don't know how they act normally. This is the first time any of us have seen Ross Harris act anyway, other than sitting in a courtroom. And so it's open to interpretation. And there are a lot of people who think this looks like two parents who have just suffered a tragic loss, and they're bewildered as to what to do, where to go from now, and they're leaning on each other. That's one way of looking at it. Another way is that, she doesn't say anything about her son. All she is talking about her husband. There are other people that talk about, Ross is not saying a word to Leanna about how careless and this, that, and the other. He may have been with his online activities, not only that day, but in the days, weeks, and even years leading up to it. So everything about this case seems to be, for the most part, open to some type of subjective interpretation. It goes back to the defense's theory that, the police are interpreting it one way, and that objectively it can be viewed many other ways.
Well, yeah, I mean, the biggest topics, the biggest thing we talk about when we talk about these two and reaction and what was said and what not said is, what is the correct way to grieve? How are you supposed to be looking and acting when you just found out your baby died a horrible, horrible, awful death? Is there shock involved? So I don't actually want to judge on what's correct and what's not correct. But what we all do while we watch this is bring our own personal experiences into it, or our personal feelings and how we would feel if we just found out our toddler roasted to death all day long in a car. I'm telling you right now, I would have walked, and my husband's a great guy and I love my husband. I would have walked in that police room and I would have said, "What did you do? How did this happen?" I would have just been like hysterical. That's the first time they'd seen each other. I don't get it. I don't get these two. At the same time, I don't think Leanna's in on anything. So for me to have that opinion, she's just weird. The whole reaction was just strange. I don't know. I don't get it.
Well, I've asked myself, how would, I've got children. I've got a son that looks a lot like Cooper, to be candid about it. And if Cooper were alive, they'd be about the same age. And I've asked myself, how would his mother, my wife, have reacted if we were in that situation? And I honestly don't know how she would react. And I don't know how I would react. So I get the point. Yeah, and I understand people's confusion. I understand that Detective Stoddard believes that Mr. Harris should have been in a catatonic state, I think was his words. And maybe he's right. I don't know. But that evidence alone is, if it's evidence at all, doesn't carry the day. But here's what it does, though. This is why I think the prosecutor had to start with that. It explains why they were suspicious of him in the first place. It explains why they didn't just take it at face value that this was a tragic accident, because they know that accidents do happen. But because of the way these two acted, whether they were correct or not, the police thought it was odd, and it explains why they decided to look a little bit further.
Right, that's true. Okay, let's talk about the charges a little bit. Actually, staying on this topic, Maria asks, was the statement by Leanna at the daycare true, or was it part of many misconceptions? And we talked about that already. The statement that she allegedly made was, I bet Ross left him in the car. I'm paraphrasing, but that has not come out in trial. So that's the only thing I can say, is that's not come out in trial. So was it true? Nobody's testified to it yet except Detective Stoddard in a probable cause hearing. And it was what he says, she said to a daycare worker. That's where we're at with that statement about Leanna. We don't know if she did say it. What's the whole context of the conversation? Was there a lot before that? We don't know all that yet. Okay. How about, and another question was about their marriage. They are divorced. Leanna did stick by him for quite a long time. But so in case people don't know, she does not believe he intentionally killed Cooper. And she's very upfront about that. She does not believe that he did that. But she did divorce him earlier this year and filed for divorce. I mean, look, he's probably gone for a long time behind bars, but I'm sure she divorced him after all of the extramarital affair information came out and all the sexting and all that. But she's going to testify, and she's going to testify for the defense. And yeah, he's a creep. And yeah, I'm sure she's reeling from all of this that's come out about how he was during their marriage, but she doesn't believe he killed Cooper. So that's going to be a very interesting testimony. All right, let's talk about the charges, because people get confused about the charges, and I'm going to quickly just tell you. Count 1 is malice murder. Count 2 is felony murder that relates to count 4. Count 3 is another felony murder that relates to count 5. Count 4 is cruelty to children in the first degree, maliciously caused Cooper Harris cruel and excessive pain. So we'll break that down. Count 5 is cruelty to children in the second degree, and that's with criminal negligence caused Cooper Harris cruel and excessive physical pain. Then he has count 6, 7, and 8 that relate to his sexting with minors. sending them images, requesting that they send him images. So those are the 8 counts. Now, Phil, people are confused about the felony murder charges. So first of all, just to talk about count 1. What would they need to find him guilty of malice murder?
Okay. Georgia, until actually, believe it or not, 2 weeks or so after Cooper died, did not have anything like a second-degree murder law. They had passed a law in the spring of 2014 that did not take effect until July the 1st of 2014.
2 weeks after this.
Yes. So the law that was in effect at the time, Georgia only had really you had malice murder and you had felony murder, and there are no degrees of murder. And so under the law that applies at the time this took place, malice aforethought, it's a legal term, but basically for our purposes, we can say that it's premeditation, deliberation. It's something that they did intentionally. Doesn't require a long term of premeditation. Malice can be formed in an instant. But it does, and you don't, and the law says it can be expressed or implied. So here we're talking about circumstantial evidence. That's the implied malice. And it's basically where the circumstances of the killing show the words of the law is an abandoned and malignant heart. So let's just think of it as evil. Okay, so malice murder under these circumstances have to be evil. Now, if you take it as the truth that this was a planned killing, I don't think there's anybody that would deny that would show an abandoned and malignant heart, because there's really no more torturous way that I can think of to die or to kill someone. So there's no question that it would be malice if they could prove beyond a reasonable doubt that he planned this. Now, the other types of murder are if you have a death, and by definition under felony murder, it's an unintended death. But if it is a natural consequence of an underlying felony, in this case, he's charged in counts 2 and 3 with felony murder. The underlying felony for count 1 is cruelty to children in the first degree, and the underlying felony in count 3 is cruelty to children in the second degree. Now, cruelty to children in the first degree, the criminal intent element of that also is, it says willfully deprives a child of necessary sustenance, or this is where they're going with this particular indictment, maliciously causes a child under the age of 18 cruel or excessive physical or mental pain. So counts 1 and count 2 are grounded in malice. Count 3, however, is a felony. It's cruelty to children in the second degree. Standing alone, it basically means if you have criminal negligence and you cause a child under the age of 18 cruel or excessive mental pain.
Okay.
So
let me stop you right there. Let's just stop for a second. Okay, so the felony murder charges, we have some very astute trial watchers that this isn't their first rodeo, and they've watched a lot of trials, so they get what felony murder is. But a lot of them were confused, thinking that if he's guilty on the sexting charges, which are counts 6 through 8 and are felonies, that would be felony murder, and that's a done deal, goodbye. And now you've just explained to us those counts 6 through 8 are not the underlying charges that go with felony murder. So I just wanted
there's only the last 2 counts in the indictment are actually misdemeanors, and the criminal attempt statute is a felony. It's a very low grade felony because attempt carries half the sentence that a completed offense would take. And it goes back to the old common law. Basically, the felony murder doctrine at common law, you had to have a crime that was, the Latin word is malum in se, evil in and of itself. Some things are felonies, but they're not necessarily evil. For example, possession of cocaine, all right, is a felony under Georgia law. It's not something that is in and of itself evil. It's only illegal, and it's only a felony because the legislature has deemed it as such. So it's not wrong in and of itself to do those things, to possess that substance. It's only illegal because the legislature deemed it as such. So count 3 in this case turns on the concept of criminal negligence. Now that's more than garden variety negligence, like if you ran a red light accidentally or whatever. It's criminal negligence, and it's
well. So you're actually talking about count 5, because count 2 and 3 are the felony murders. The two cruelties are 4 and 5.
Count 3 is a felony murder, but it's predicated on cruelty to children in the
criminal negligence.
Yeah, and so that's so I apologize. I'm looking at my screen. I'm looking at the indictment. Cruelty to children in the second degree. It says with criminal negligence did cause Cooper Harris, a child under the age of 18, cruel and excessive physical pain. Now, so that says criminal negligence, and if it's negligent, then by definition it's not malicious, and vice versa. So those two are arguably inconsistent, but nevertheless.
Okay, so you and I have talked about this, and I want to talk about it in lay terms. What needs to happen for the state to find him guilty, or the jury to find him guilty on count 5? What criminally negligent? So I think that's the one that most trial watchers now think, oh, that's the one they're going to get him on felony murder. So what do they need to prove for criminal negligence?
They're going to have to prove more than ordinary negligence. They're going to, it's got to be more than an accident, but it's also got to be more than garden variety negligence. When I say garden variety negligence, that's the kind of negligence that we think of when we think about, say, a slip and fall because the grocery store didn't mop up the water and somebody fell in it. They were negligent in maintaining a clean floor for their customers. Criminal negligence goes beyond that. It's really, really, really bad negligence, and to the point that you really should have known something. You were reckless disregard of something that you were really, really aware was a very substantial risk. And I'm trying to speak in layman's terms, but it's
let me interrupt you.
Negligence on crack.
I'm sorry, negligence on crack. We discussed this a lot in our chat room. That's why I wanted to spend more time on this and break it down even further for the people that aren't familiar with legal stuff. He doesn't have to have been committing some other kind of crime to have criminal negligence, right? That is what was talked about by some people. For instance, they say the crime could have been him sexting at the time, but that's not what we're talking about with criminal negligence, right?
Yeah, it's really a jury question as to what criminal negligence is. I can't give you a precise definition, but suffice it to say that it's more than mere negligence. And there's a lot of people that believe that at this point they've proved criminal negligence. They by virtue, I apologize, my cat's making noise in the background. They've proven, a lot of people think that he has been criminally negligent because of he was engaged in this whisper conversation. I think the testimony was, right as he was pulling into his place of work, and his mind should have been on driving Cooper to daycare. And so a lot of people believe that in and of itself is enough to rise to the level of criminal negligence.
And that could be, right?
Could be. Yes, absolutely. It could be. If the jury believes that that's the case, then yes, they could find him guilty just on that basis.
I'm so glad you cleared that up. Okay. Let's get some more questions. Okay. So I Love Trials says, do you think the state will call Leanna Harris the state? And if not, how will they counter her testimony when the defense calls her? And I think that's based around the fact that we think she will say she does not believe Ross intentionally did this. Now, I will say that she was on both. She was subpoenaed by both, but I've heard now that the state isn't planning on putting her up. What do you have to say about that?
I'd say the chances are that the state will call her because they were basically dared not to do it by the defense, an opening statement.
And these attorneys.
They may, but then again, I mean, I could be proven wrong. Chuck Boring and his team, they're not stupid. They might prefer to get her on cross-examination rather than have her on direct examination. Because if they get her on direct, they're going to have her declared as a hostile witness, which unless she shows hostility and she's not willing to answer their questions, they're not going to get that declaration. So as a matter of strategy, they may very well take up the defense on its offer to let them call her in their case. That way they get her on cross-examination. Either way, she testifies.
Okay. Let's talk about Ross's police interview. So we touched on when Leanna finally got there, and we saw that interaction between the two of them. But backing that up, when Detective Stoddard had him in, was questioning him, there's so many parts to that. He's not really hysterical. You know, I don't really know how to say he was acting. He also says a few strange things, and now for the last 2 years, we have heard that when he was told what he was being charged with, he said to Detective Stoddard, but there was no malicious intent. Now those aren't words that a normal person uses, and Detective Stoddard thought that was suspicious. Well, that was not caught on video, him saying that, and we've seen the video. And Detective Racy testified today that he was in the room, and when Ross said that, he flipped on his recorder and started recording. So they turned it on after he said those words. But what we do see on the video is Detective Stoddard then a little bit later in the conversation says something to Ross like, you know, it doesn't say anything about malice. So for some reason he says that. So I tend to believe that Ross did make that statement. And they think that's suspicious. I don't know. Why don't you talk a little bit about Ross's interview, and I'm going to put a picture of him up.
Yeah, so we've got, it's not on video, and it's not on audio, but we've got, you know, 2 witnesses that say they heard it. And the judge is going to instruct the jury that all witnesses are presumed to tell the truth, although the jury is free to ignore them if they don't believe them. So I think that it's fair to say that, you know, that statement probably was made, and I don't think really the defense has denied that he made those statements. We did hear Ross in his first interview discussing various criminal statutes, speaking in certain types of legalese, if you will. But keep in mind, this is a guy who's been associated with law enforcement in some capacity. He's got relatives that work in law enforcement. He may very well have been exposed to any number of things. You know, even before I was a police officer, I was a criminal justice major, and I was familiar with the term malice. So there may be a non-criminal way of viewing this. And again, I'm playing devil's advocate, not taking sides. I'm simply pointing out that there may be another way to look at it. That said, I do understand why it would cause police to be suspicious. I have participated in police interviews. I have conducted them. I've analyzed them as a prosecutor, and I've seen a ton of them in my law practice. And I don't think I can name any person who's talked with police who has used legalese in this way. So I do see why the police might raise an eyebrow, but I also can see that Ross Harris is not your typical defendant because he does have at least some background, not as a police officer, but with a police department, and he's hanging around with cops, and that's the way they talk.
Okay. Right. Well, right. So the background of Harris is he spent so many years as a police dispatcher in dispatch, and his brother is a law enforcement officer. So that probably also lends him to knowing terms. Also, if we've learned nothing else about Ross Harris, it's that he will Google anything, he will look up anything, he will search anything. So he's just kind of that kind of guy. So I don't know that I think that means he looked up ahead of time about malicious intent, but you know, I don't know. I tend to keep giving him the benefit of the doubt, and people hate that because really,
the jury's supposed to do that.
Unlikable, you know, right? He's very unlikable.
Yeah, you're supposed to. I mean, we're supposed to give people the benefit of the doubt, and it's hard when you have someone who is, by the defense's own admission, a shameful person. I mean, none of us, you know, I think would have him to our home for dinner, for example. But does that make him a killer? And that's really the essence of this case. And Mr. Boring said as much during his opening statement. He said, "Look, this case is about malice," and I think that's how it's played out at this point. I think this is about malice. I don't think there's any question. If the jury believes the victim who's testified, the underage victim, if they believe that he sent pictures of his private parts to her, and that he requested that she, at her age, do the same thing to him. If the jury believes that and believes that that's proof beyond a reasonable doubt, then he's guilty of at least the sexting charges right there, and that's 12 years. So
that's a question that a chatter has for you. Do you think he's dead to rights on count 6 through 8, the sexting charges? Do you think that's just a given?
Well, we didn't see and we didn't hear her testimony. We've heard descriptions of it, and I think, though, that it's fair to say that the defense probably didn't challenge her too much on that. They might even have conceded those counts as a practical matter, because if that's all he's convicted of, that's 10 years on the criminal attempt to basically the sexual exploitation of a child is Georgia's child pornography law. It carries 20 years if you complete the crime. If it's an attempt it's half of that, so it's 10 years. The other 2 counts are misdemeanors, 12 months apiece, and if Judge Staley were to give him consecutive sentences, that's where I come up with the 12 years. So if the jury believes her testimony and that it was credible, then right there, they're at 12 years. But, 10 years plus 2 misdemeanors is a lot better than a mandatory life sentence plus some. Keep in mind, he's got another indictment coming behind this, but as to this case, 10 or 12 years looks a lot better for someone in Ross Harris's position than a mandatory life sentence if he's convicted on any of the murder charges.
Right. So, okay. So that clears that up. That's another question we have, is what kind of time is he looking at? You believe he's looking at 12 years on count 6 through 8, and everything else is life if he's found guilty of that. You did just bring up oh, go ahead.
The cruelty in the first and cruelty in the second, if he's convicted of those are also felonies, but they bootstrap into felony murder counts. So if he's convicted of felony murder, say in count 3, that underlying charge of cruelty would blend into, I think, the felony murder count. So he couldn't receive a consecutive sentence, even though he might have been found guilty of that underlying felony.
Right. And then since you brought up the other indictment, by the way, on courtchatter.com, we have an archive page on this trial. You click on the archive tab, and you can find any defendant in any of the cases we cover by their last name. And on his page, we have all the charges and counts listed out with the explanations. I also have some links to the statutes, the Georgia statutes that they go with. And then you mentioned this second indictment, and you can also find that on that page. And in March of this year, of 2016, he was indicted on 8 additional counts. Now, why don't you tell us about that? That is not included in this trial.
No, and it's going to take me a minute to scroll to it here. But you're right. The explanation that they gave for
all the decimation of harmful material to minors, and then that.
Yeah, so it's more of the same kind of sexting, but it's more than a mere attempt to commit sexual exploitation. It's 8 counts. Count 1 and count 4 are sexual exploitation of children. So that's two charges that carry up to 20 years each. If convicted, he's facing 40 on those alone. If the judge were to run those consecutive, the dissemination of harmful material to minors, that's counts 2, 3, 5, 6, 7, 8 of indictment number 2, are misdemeanors. So each one carries 12 months. That's 10 plus 10 is 20. 1, 2, 3, 4, 5 is another 46 years if convicted. And that's assuming he's convicted on every count and the judge were to sentence him to the max and to run them consecutively.
All right. So that's the other charges that we were just briefly talking about. So after this trial, no matter what happens, he's facing 8 more counts.
He's facing 8 more counts, and he's facing potentially another trial unless they cut him a plea deal. Or it's possible that if he's convicted on this, they may elect to not try him on that and just kind of wait and see what happens. But that's a decision for the DA to make. I wouldn't presume to speak for the DA.
Okay. All right. Let's get to, because I have several different questions that concern Cooper in the car seat being shown the model and the jury view tomorrow. So I'm going to kind of lump that all in together. So just so everyone knows, Tomorrow, the jurors will take a little field trip outside of the courthouse, and they will see Ross Harris's car, his SUV. It's been shipped in from Cobb County to where they are. This was a change of venue. I think everyone watching this probably knows this. To get a fair jury, they've gone 300 miles away from where this happened. So they have shipped the car in, and the jurors get to go outside tomorrow and see it. And the details we have about that is they can walk around the car, they cannot get in it, and they cannot touch it. So those are the rules tomorrow. Someone asked me if we are going to get to see it. The judge is allowing one pool camera. I don't know if it'll be live streamed or if we'll see the video after. Phil, have you heard about that particular with 11 Alive?
I haven't heard anything through any particular media outlets, but it's my understanding is that you're correct, the media will be able to shoot photographs or video of it, but not with the jury present. So this may be something that we see, those of us watching it online may see what the scene looks like before the jury gets there. It's all going to be set up. Yeah, and I guess it may be a game time decision about whether or not they show it. It could go to black while the jury's out there, and they could show what they shot earlier. I really don't know. And the pool feed is not always, the media outlets can't control the pool feed and how things are presented to them. So we may just have to wait and see. But yeah, I think we'll see it. We may see it early in the morning, but we will not see the jury out there looking at it.
Yeah, knowing what I know about live streaming cases, I'm assuming we will not see the live stream happening live. That what you said is true, that we'll get shown shots of what the jury's going to see or what they just saw, but they are not going to take a chance of showing a juror member on TV and on camera. So I'm assuming it will not be live while they're out there, because what are they going to show us? They'd have to turn the camera away from their cars.
Right, because the jury's going to be walking around it, so exactly. They have to do it before or after. Now, the lawyers are reporting, it's my understanding that they're getting there early so that they can make sure everything is set up right. And so maybe that's when the media gets to take a look at it.
Okay, good. Okay, so in the car will be Cooper's car seat. So they are allowed to put the car seat in there. The defense objected to that. They didn't want the car seat in there. They were saying things like, we have no idea exactly how the car seat was placed, and we can't recreate this exactly. And anyway, the judge denied that, and the car seat was placed. It's already been placed in there. It's in there right now. But let's talk about this 3D animation. The state had an expert have a doll, basically a Cooper doll. It's a Cooper-sized mannequin that they placed in the car seat in the car for a recreation, a 3D scan that they are doing and showing to the jury. But that doll will not be placed in the car for the jury view tomorrow. So I got that answer that it's just the car seat will be in there. But I will show you what the jury saw today, and I'm going to share that here on the screen of this recreation they did. Now, you'll have to look at this. You'll have to look at this picture carefully if I can get it shared correctly. You can go ahead and talk about this if you want to while I'm trying to get it pulled up.
So what makes sense, and the way I would try this case if it were mine is I would have the jury go and take a look at the car with the car seat. And then I would come back in the courtroom. I would have my expert who did the 3D animation then do that presentation. Now, they've I think testified that they used the doll or mannequin, however you want to call it, in the 3D presentation. So that is going to basically take the jury. They're going to say, look, here's the actual car and here's the car seat. Now let's go back in the courtroom. Then we'll dig a little deeper into this thing through 3D animation technology, and we'll see what might have been in Mr. Harris's peripheral vision or direct vision as he's walking to the car and looking at it from various angles. We also, I think, might see, using the 3D animation, what it would look like from being, if you were seated, for example, in the driver's seat. I think a lot of people want to know, if you just looked in the rearview mirror and didn't turn your head to either side, what might you have seen?
That's going to be very important. Okay, I have on screen right now what was shown to the jury today, and it was a picture when they were recreating this, doing this 3D animation. Now, if you have to look at this closely, you can see the driver's side with the steering wheel. So I'm just trying to get you, so you know what you're looking at here for the audience. And in the back seat, they have the red rear-facing car seat, and you see a blonde head sticking up out of that. That's the doll, the mannequin, that's Cooper-sized, and the car seat. So just for those that are seeing this really small on their screen, that was shown to the jury today, just still pictures when they were creating this animation that they are going to see at a later time. They haven't seen the animation.
That particular picture that you have shown there, if I'm not mistaken, the windows are rolled down in the back seat.
And that actually, thank you, that is important, because when he went there at lunch and when he went there after work, his windows were rolled up. So that is something I'm sure the defense will get into, or the state will preempt that and show it both ways. But this particular picture that I just had up on the screen was with the window rolled down. But it does give them the look at what it would look like. You know, for me, yeah, his head's sticking up over the seat, but when you look at it from this angle, it's not how I had envisioned it. So I'm really curious to see that 3D animation and see how that comes up. Okay, let me get it.
Well, I think the key there, and I think one of the points is that the prosecution wanted to make, is that even when you're looking at it through the open window, you can see that the child's head rests higher than the headrest, and that just makes common sense. And so the idea is, if you remember, Mr. Harris testified that he merely glanced to the right to change lanes headed to the movie theater, and that's when, according to his statement, he saw it and knew right there that something terrible had happened. So if a mere glance to the right, the prosecution will argue, is enough to notice that blonde hair that's up higher and is arguably longer than the car seat, then the argument that they're going to make is that how come he didn't notice it for the other couple of miles before he got there?
I think the fact that Cooper had blonde hair says something and doesn't fade into the background of that black. It's black and then red on the car seat. Okay, Sandy asks, do you believe if jurors can see Cooper's head tomorrow in the car? Okay, now we just talked about that. The doll will not be in the car seat. But it says if they, so let's just put it out there generally. If they believe that Cooper's head can be seen in the car through the door or the window, will that go toward malice?
Yes, it will. But the question is not whether Cooper's head or that portion of the car seat could be seen. The question really is, did Harris actually see it? And, you know, again, playing devil's advocate, if I were the defense, I'd say, listen, this is the guy who's so preoccupied with everything under the sun except what he's supposed to be doing. He just walked up there, tossed the light bulbs in and walked back into the office. And he never had an opportunity to put his head in there. He didn't put his head beneath the top of the car, and he just wasn't paying attention to anything. So, whether or not it's possible to view, like right now, I can look at my computer screen and I can see, right into your eyes. That doesn't mean that I'm looking at your eyes, even though I can. Okay.
Oh, right.
I can also look at the green light on my camera at the top of my computer. So it doesn't mean just because I do have a view of something that's somewhere around me that I'm actually looking at it. And I think that's where the defense is going.
So that's an important point. For me, it's important. I would love to see, and I guess we'll see that at this 3D animation. I want to see what he would have seen at his height walking up to that car. Now, what we do know, if we know nothing else about Ross Harris, is he is distracted all the time because he is obsessed with chatting with these women and girls. And we see that going on constantly because they have the records for that. You can also see him on his phone in some surveillance, the parking lot cameras and stuff. So he is a very distracted person. So your point is very valid that just because he's walking up to the car and you and I could have looked right there and stared in the back seat and saw Cooper doesn't mean necessarily he did. Or he's a killer and he did. So, we have we have both options there. You and I tend to keep giving the defense side of things. So maybe I should flip and start being the prosecution. I don't know.
Well, it's the prosecution's, I think, strongest evidence that I've seen is, well, it's two things really. It's the tightness of the interior of that vehicle and how close the car seat, and now, as we've seen through this mannequin, where Cooper's head would have been to Mr. Harris's right shoulder area, was really, really, really close. So if you take that and you combine it with some facts, like he had an opportunity to look to his right to pick up his Chick-fil-A cup and walk before he walked into the office. He also looked to his right. I think the testimony was to get the briefcase from the floorboard, or that had the laptop in it. And so to turn to the right to do both of those things, you had an opportunity that you missed to see your son. The other coincidences possibly that the prosecutor is going to say aren't really coincidences are that he had to make a right turn to leave his place of work. He had to go through several red lights and make several other turns. And, when you're clearing to look left or right to make turns, that mere glance that you missed, all these things are very coincidental. And you take one thing, two things, three things, and four things that, it becomes more and more hard to see something as a mere coincidence. And so I think we may hear more about that, but I've been monitoring what I'm seeing on social media and what I'm seeing in the chat rooms, and a lot of people are saying this is just too much to be coincidental. On the other hand, there's always another hand with lawyers. Harris is not your typical person. He's very distracted, as we've seen by his extracurricular activities, and so who knows? Who knows? There may be more than one way to look at this, and the real question is, how does the jury see it? Is it reasonable doubt for them?
And I'm going to talk, I don't want this show to go on all night long, but I do want to briefly go over the description of jurors that I have. But first, let's get to some more questions. So Linda asks, why didn't Ross take the larger car with the front-facing car seat since his wife was working in the area that day? Well, if I can just answer that, then I'll get your opinion, because the larger car isn't his car. It's not what he drives. And he's the one that takes Cooper to he takes daycare. I think they said maybe the majority of the time, or 75% of the time or something. He didn't ever take the other car when he was taking Cooper to daycare. So I don't know why that day would be any different.
Yeah, well, they've addressed that, and they've given really logical explanations for it. And those of us who have been parents of small children, we know how much of a hassle it is to transfer car seats until they get to the booster seat. Those when it gets a lot easier. But when you have those car seats that you have to really strap in or buckle in or bolt in, whatever.
Yeah, there's straps in the back. There's all kinds of straps.
It's so much easier to get two of them, one for each parent, rather than to be swapping it back and forth all the time. And I think they gave some reasonable explanation as to why Leanna had the forward-facing one. Cooper was at that age when he was transitioning into, and maybe should have already been in a forward-facing seat the whole time. He's 22 months. He's a couple of 3 inches longer than the guidelines. So he's right there where they're, it's reasonable, I think, and understandable why a parent might say, we just hadn't got around to getting a second forward-facing seat yet.
Right, and Ross, I guess, talked about that through Detective Stoddard. We heard that he talked about how they each had the infant seats, and for those parents, we know that you can transfer one seat from base to base. You just buckle the base of it in your car, and then you take out the seat and put it in the other car, and that's how a lot of parents have it. And they had just recently got him the forward-facing one, and that had been in Ross's car, but he had switched that because Leanna was going out of town to Alabama, where they're from, to take Cooper. So he had put the forward-facing one in Leanna's car. And so that's why the rear-facing one was back in his car. But you're right, at that point, they didn't have two forward-facing cars. And Linda is asking in the chat room saying, oh, so he was not driving his wife's car. And my understanding is no, Ross always drove that silver SUV, correct?
That's my understanding of the evidence as well. And,
okay.
And so Leanna had, we've seen pictures of the forward-facing seat. It was in her car. It was in her car when she pulled up to the daycare that afternoon.
Right. And she's the one that would pick up a lot of times after work. So, it's not like they would just switch this car seat back and forth. At some point in time, Cooper's going to be in the infant rear-facing seat if they don't have two forward-facing car seats. That's how they were doing it. The manufacturer says his age was okay for it still, but his head was too big over the top for it. So he really.
I personally think he was too big for the car seat.
Yeah.
They should have had him in a forward-facing seat.
Yeah.
And let's pause for a second and think about that. If you add that fact into the extracurricular things that were distracting him, that's another factor the jury can consider when they consider criminal negligence.
Uh-huh.
You knowingly made a decision to keep your child in a rear-facing car seat when you knew that they were supposed to be in a forward-facing seat because they were 3 inches too tall.
So you're so smart, Phil. That's why we are glad we have you. All right, let's run down through some more questions. Linda also wanted to know about this 6-minute call. So at the scene, after Cooper's been pulled out of the car, and Ross goes off and gets on his phone, which has been a topic of a lot of debate on his reaction there at the scene, and that he's not over Cooper or grabbing Cooper and all that, but he's on the phone, and we have testimony now that he tried to call Leanna first, and it's like a 20-second call, so we don't think he got through. And then his phone makes a call to the daycare. And they testified that you call and you get like, hi, this is the daycare. Please press this extension for this room. And that he pressed the extension to go to Cooper's toddler room, which is toddler room 5. Now, they don't have the details of the phone call. Now, they have cameras in the toddler room, in the daycare room, and they can see.
Hall.
They didn't. Oh, the hall. That's right. They don't see anyone picking up a phone. But during the time, they know the time frame of that 6-minute call. They only see daycare worker Michelle Gray go in the room and out of the room, and they see nobody else. So because of that, police deduced that he must have called her and talked to her for almost 6 minutes. But guess what? She says absolutely not. She never spoke to him that day. She doesn't know what they're talking about. She never spoke to Ross Harris that day. And they grilled her and brought her in for a second police interview. And they asked her if she had a relationship with Ross. They were all over her. And she's testified in this trial. It's Michelle Gray. By the way, we have the archives of the trial on our YouTube channel, Court Chatter View. That's different than this YouTube channel. And I have started to label each archive with the witness names. So go back and find Michelle Gray and you can see her testimony. She testifies that she didn't, and she was offended that they were treating her like that. So, Phil, the question to you is, do you know anything about this 6-minute call?
Well, what I know, and I'm looking back over my notes and things, the Home Depot records show, and this was testified to in court, that Ross Harris's phone actually called the main switchboard and then was transferred into the toddler room. Harris himself said in his interview that he called the toddler room, and that's what the Home Depot records show. His cell phone itself showed a 5-minute call, and I think iPhones round to the nearest minute, and I think they said that Home Depot records round up. So they said 6 minutes. His phone said 5. So Harris himself said he called the toddler room. The Home Depot phone records show that the call did not stop at the main switchboard, that it actually was routed into the room. Now, that's a mystery according to the police and the prosecutor. I was surprised to learn that there were no video cameras in the actual toddler rooms, but they apparently were in the hallway.
Yeah, why?
So
yeah.
If this witness was the only one, in the room, if they had evidence that she was on the phone with Ross Harris, and let's face it, I mean, at this point in the investigation, if you were the police, wouldn't you wonder if Ross Harris isn't having some kind of relations with everybody under the sun? So,
well, that's exactly what they were wondering.
I get why they might be suspicious of her. And if they had any evidence that she was lying to them, they would have charged her. But all they have on her was really nothing. They just have that this call was made to the toddler room 5, and it lasted for 5 minutes. Witnesses on scene said they heard Harris actually talking, this witness has said she wasn't talking to it, and they can't prove otherwise, and so she hadn't been charged, and it is going to be one of the perhaps everlasting mysteries of this case, regardless of the verdict. But
I mean, I don't even know what to deduce from that. First of all, you can go back and watch Michelle Gray's testimony yourself. For me, she was credible.
she seemed credible.
I believed her when she said she didn't talk to him, but I don't know what to make of that.
The DA didn't challenge her on it. They didn't go after her. They didn't accuse her of anything. And if they thought that she was lying to the police, I promise you, she would have been under arrest.
And thank you for that. Thank you for reminding me of that. That's exactly right. The DA didn't even bring it up in their direct examination of her at all. This came up in the cross-exam from the defense, saying the police were accusing you, the police were doing this, bad police, bad police. And that's the only reason we know about it. I don't know what to make of it. I mean, a lot of people are saying maybe he was faking talking to somebody. Maybe he was faking on the phone. Now, we do know the phone connected, though. It was almost 6 minutes long. And police and other witnesses on the scene say they heard him talking on the phone. They don't know what he was saying, but they heard him. Some people think maybe he was faking it so he didn't have to go help Cooper or didn't have to talk to Officer Piper when she walked up. I don't know. I don't know what to make of that, but I'm going to just move on from that for right now because we have some other things I want to quickly get to. Goats Girl, Lynn, a couple other people are talking about family members, so I want to talk about that really quick. One thing we see as trial watchers is how empty that gallery is. There is nobody inside that courtroom, and that is not what we're used to seeing on a high-profile case. Now, my guess is because it's moved 300 miles away, it's not right there where this happened. And but people in Brunswick are like, I'm not going to spend my day in this courtroom at this trial. Like they don't have their best.
They have lives. They have things to do.
And you, Phil, had gone to all almost of the pretrial hearings when they were in Cobb County, and you were in that courtroom. But even then, it wasn't packed, right?
And the reason for that is that people have other things to do with their day. People, other than lawyers and trial watchers, I guess. But
yeah, we don't have anything to do. This is our life.
But the other thing about it is, and even when the proceedings were being held in the Cobb County Courthouse, I spent a lot of my time in media trucks, satellite trucks outside the courthouse because I didn't have to put on a tie. I could sit there in the air conditioner and watch it on the monitor, listen to it in my ear, or I could go in the media room, which is more comfortable. And you didn't have to be as quiet, and you don't have to maintain the decorum that you have to maintain in a courtroom. So you're in a place, for those of you who might be watching that aren't familiar with Georgia, that part of the Georgia coast is pretty much out of the way. You have to intentionally go there. So the people that I've seen in the background are people that have a vested interest in this particular case, people associated with the media or one side or the other, and a few attorneys that I've seen that are like myself, monitoring the case and talking about it. But it's so far out of the way, so far away, you literally, there's no good way to get there by car, at least, from Cobb County, Georgia, down to Glenn County. No direct route. You have to go to Macon and go to Savannah, then south, or go south towards Tifton and then over way to the east. And it's just really far out of the way. So that explains it, along with the fact that the media can't have electronics in the courtroom. Even the newspaper journalists, they can't have their laptops that they used to take notes on. So they have to go to the media room, and they're watching the live feed because that's where they get to have their electronics. Even lawyers who, like myself, if I were to go down there, and that was the plan originally, except the hurricane, I wouldn't have been able to take any electronic devices into the courtroom. And so the journalists are doing it the old-fashioned way, and if they're in the courtroom. So when these minors testified, the journalists went in and they had the notepads out, but they couldn't take any electronics in whatsoever. So that has a lot to do with it.
Right. Yeah. Right. And that's important to mention that because we see it done both ways. It depends on the court on whether you can have electronics in the courtroom or not. A lot of people are bringing up where are the family members? Where's the support for Ross, or where's the support for Cooper, the victim? One, I think the distance is far, although in the chat room they're saying, but Travis Alexander's family traveled from California to Arizona for that entire trial on the Jodi Arias trial, which is what a lot of trial watchers are familiar with. I will say that they had a lot of funds. They had a lot of fundraisers to get them to do that. I don't think that anyone in the Harris camp is going to get any money raised for them so they can stop working and go hang out for 2 months in another county. Secondly, I'll let you talk about if they're, now we don't know, we don't have the witness list. It's not published on each side. So we don't know exactly if her parents or his parents are on the witness list, which was a question I had from somebody. But if they are on the witness list, like Leanna, why don't you tell us what Georgia says about that, the Georgia law?
Yeah, so the witness lists have to be.
Being in the courtroom, I mean.
Pardon me?
I meant about being in the courtroom as a spectator if you're on the witness list.
Well, if generally speaking, witnesses are subject to what we call the rule of sequestration. It means that witnesses can't be in the courtroom while other witnesses are testifying. Generally speaking, if that witness is finished testifying and they're released from their subpoena, then they can hang out and watch the rest of it. There's an exception for the lead investigator that in the judge's discretion, the judge can permit certain people, typically the lead investigator, excuse me, to remain in the courtroom if they are necessary to the orderly presentation of the evidence. So that's why we've seen Stoddard in and out as this trial's progressed. Excuse me. Other witnesses, even if Leanna Harris, for example, she's subject to the rule of sequestration as well. Now, there is an exception that could have been potentially invoked if she'd wanted to invoke it so that she could be present as the next of kin of the victim, the alleged victim. We've also seen people in the courtroom who I suspect were in support of some of the other young women who have testified. We've seen them. They're not witnesses in the case. They're just there for support. But for the most part, all witnesses have to stay out of the courtroom until their testimony is over. The only exceptions would be the lead investigator, and if the judge deems it appropriate, potentially Leanna Harris. But, as you say, they're divorced. I'm sure she taking them at their word.
It must be a real conflict for her, I would think, because
she doesn't want to hear all this stuff.
She's not looking for justice for Cooper because she doesn't believe that Ross did it. So right. She's not really there. She's not there saying, I need someone put behind bars for this.
Right. That and she also doesn't, I would imagine, want to hear all the salacious details over and over and over again. And, for that matter, she could be watching it online just like the rest of us. So
I wouldn't doubt it, although she's not supposed to, right, if she's on the witness list? Okay. On that same note, Goats Girl asks, will Leanna plead the fifth?
No, I don't think she has anything to plead the fifth about, and that might be part of why some of these questions came out about her being a suspect. But her attorney and the defense have said to us that she's going to come to court and she's going to back up Ross on his claim that it was an accident. And I got to take them at their word. I know Maddox Kilgore very well, and he is not foolish enough to stand in front of a jury on a national stage, if you will, and say, look, if the prosecution doesn't call her, I'm going to call her. And here's what she's going to say. He's not foolish enough to do that unless he knows that she's going to say those things. So I think she's going to testify. I don't think she's going to take the fifth. And from hearing Stoddard testify, I don't think she has anything to take the fifth about.
Right. Okay.
I could be wrong, but as I'm reading it, that's the way the tea leaves appear right now.
Well, I agree with that. Allison asks, if found guilty, will the sentencing be back in Cobb County or will they have to go back to Brunswick?
In all likelihood, they want to get out of Dodge and get back up to Cobb County and everybody get back to their lives. And if there's a sentencing to be done, there certainly won't be any hurry to do it. So Judge Staley is going to want to get out of Glenn County, give those people back their courthouse. And, at some point, guests can overstay their welcome. And so she's not going to want to be that guest. She's going to want everybody to get out of there, get back home as soon as possible. The lawyers, I know, want to get back home. They all have family. They have the defense side. They've got private practices to take care of. The prosecutors, they're married. They have kids. They want to get back to their families. And so everybody's going to come back to Cobb for any further proceedings after the trial.
Okay, great. All right. I'm just trying to wrap it up, make sure we got everybody's questions. Has Leanna
another 2 or 3 good ones out there?
Yeah. Do you think that Leanna has seen all of these messages? Have they shown her? His texting and chatting and all that?
I think Leanna has seen, if I had to guess, I would say she's seen a lot of it, maybe most of it, maybe even all of it. She certainly, I think, would understand the gist of it. And I don't know what's in her head. I've never met the woman, never talked to her. I can only imagine, though, that if I were advising her as a lawyer or otherwise, I would keep her informed to the best of my ability of the evidence in the case as much as she wanted. And for whatever reason, at some point, she decided their marriage was irretrievably broken, and she filed for divorce. And maybe it was the realization that there's no way to salvage a relationship with Justin Ross Harris. Maybe it's a realization that it's more than what she thought it was, even if she had some inkling that he was not being truthful to her or being faithful to her. Or maybe it was a realization that even if he's found not guilty of these murders, he's likely to be serving some time on other charges. So I got to move on with her life. I don't presume.
I'm thinking the divorce happened because of all of the extramarital affairs. Okay, but we don't know that. That's not what was listed in the divorce decree.
Yeah, her motivation for filing for divorce is something that may only be known to her.
Right. Let's see. Sandy says, Phil, you said, and when she says you said, I think you talked about this in our chat room. You said
everything I said in the chat room was a lie. I made every bit of it up.
Cannot be held against you.
Right.
You said you drove the route from Ross's work to the scene of the crime. Was there a shortcut to the theater from the road he pulled on, or was it going away from it, and was his home toward that way? So why don't you talk about the route when he was leaving work that day?
So, this isn't right now. My home is roughly a mile from where all this took place. And at the time, my home was much closer than that. I still conduct a lot of my personal business in that area of Cobb County. I get my hair cut right down the street from there. So in this area a lot. And I go to the movies at that same theater all the time. It's the closest and nicest one to where I live now. So I'm very familiar with this area. And I used to eat at that Chick-fil-A all the time because it was the closest fast food place.
Yeah, but tell them what you said about that, though.
Which thing that I haven't been able to go back since. I mean, since the day that this happened, I was literally stuck in a traffic jam that was near there, and it was created because the police had shut down all these roads. Wow. And I remember hearing a local radio traffic reporter who was a friend of mine on the radio talking about police activity due to a child being found dead in the back of a hot car. And, I remember my heart just breaking. I mean, the immediate assumption is it's an accident, but regardless, it's a deceased child. Everybody's, just thinks it's awful. So I was right there, literally, when this happened. And so I've driven this route. I know the Chick-fil-A. I know the Home Depot. I know that road leading into Ross Harris's former workplace. And I can tell you that the most direct route was not the route he was on. Now, that being said, can you get there the way Ross went? Yes, you can. And to do it, you would have to be making that right hand. You'd have to, from the far left lane. Ross said he glanced over his right shoulder to get into the right lane to turn right. That's what he would have been doing if he was going sort of around his elbow to get to his ankle to the movie theater.
You Southerners.
But his left turn onto Acres Mill Road, to me, doesn't make sense. That's not how I would have gone. I would have gone straight because that leads you directly around. There's less traffic. It's a much shorter route. To his left turn onto Acres Mill Road is something of a mystery. I don't understand why anyone would do that, especially if they're in a hurry to get to the movies because they think they're going to be late.
How about
there's something about that, something about his route.
Acre Mills. I'm sorry, turning left and going the way he did. Is that the way home? So like being on autopilot?
Nope, not on his way home. It's kind of on the way to the movie theater. You can get there that way. In full candor, you absolutely can do it. And if there were a traffic jam or some other reason to go around, then that's an alternate way that you could go around. But I don't think that existed that day. And so I don't know why he chose to go that way. It's not the most direct route. In fact, it goes into worse traffic. It goes into a more highly congested area, and probably would have taken several minutes longer, based on my own knowledge of the area, to get to that movie theater going the way that he went. So that's another mystery that remains to be answered in my view.
That's very suspect to me. And you know, I'm always arguing the defense side, but there's several things that I think are suspect, but that's very suspect to me. And when I say there are several things, here's the deal. What we're seeing out there in our chat room, out on Twitter, social media that you've been talking about, people that are watching and following this case, the opinions are everywhere. They are all over the board on this case. Now, is that going to be a reflection of the 12 jury members and in that jury room? That very well could be. So it's all about reasonable doubt. And I don't know. I don't know about this case, about the intentional murder. That's what I'm talking about.
Well,
I don't know about that part of this case.
Doubt is, when I try a case, I usually have a list. Among other things, I'm keeping a running tab of little bullet points, because the judge will tell the jury that reasonable doubt is a doubt for which you can attach a reason. And so I write bullet points of reasons why you should doubt the guilt, even if it's one little thing. For example, in this case, the defense pointed out that, Harris was trying to set up a sexual liaison with a woman, which on the day Cooper died, and they typically met in his car. And the point was, well, why would you set up a sexual liaison, with someone in your car if you knew that you had a dead body in there? Doesn't make sense.
Reasonable doubt.
Doesn't make sense. Now, the prosecutor, Mr. Boring, today on redirect of Stoddard, I think it was Stoddard, pointed out that this conversation, this solicitation, if you will, to meet up with her happened around 7 in the morning, give or take, before all this with Cooper occurred. And so, if it had happened at 10, 11, or 12 o'clock, it would have had a lot more weight than if it happened before he even left home. So
Right.
The prosecutor did a good job, I think, of somewhat neutralizing that argument. But I just use that as an example of it's a doubt for which you can attach a reason.
Okay, do you know who's paying for Harris's attorneys?
Sure. The taxpayers of Cobb County.
So he's been declared indigent.
Yeah, I don't know. I'm not privy to all the financial details, but I know that initially there was some GoFundMe accounts because everybody's knee-jerk reaction was, oh my God, this is a terrible accident. And then once the probable cause hearing happened, the public opinion against Harris just absolutely just evaporated. He just went south. And so the GoFundMe account went away, the money went away, the family support, a lot of it went away, the financial support. So at that point, he had no way of defending or paying for an attorney. He was incarcerated, unemployed. They fired him, and so he was declared indigent. And Judge Staley appointed these attorneys, and so every one of them involved in the case is being funded by Cobb County. You have a right to a lawyer, and if you can't afford one, you have the right to have the state pay for one, and that's what's happened here. Not only that, there's been lots of orders signed unfiled under seal that I strongly suspect are orders that Judge Staley rightfully granted, authorizing money for the defense to have experts, because let's face it, nobody wants to try this case twice. And if the judge does not provide the defense with the resources that they need to effectively defend the case in the event of a conviction, that's just one other issue for an appeal that when the judge says, look, take what you need, I'll give you within reason the resources that you need, that's just one less thing that anybody's got to worry about on appeal.
Okay, we've almost been going an hour and a half, so I'm going to try and wrap this up. I'm going to wrap up with what my thoughts are, and then I'm going to end with you, Phil, and if anything else you thought of that you wanted to bring up, and that's how we'll end it. So this is what I want to say. I want to say that every trial that I cover and watch, and I say cover and watch because I report on it like a reporter, I research it like a reporter, I read all the documents, but I watch it like a trial watcher. So I do both. And every trial, I really try and go in with the state having to prove the case to me, because that's how our justice system is, and that's how I'd want it be if I was accused of a crime. So I go in trying to give the defendant his innocence, and then you need to prove it to me, state. And that's hard because I know a lot more than the jury knows, but that's how I go into these trials. Well, and a lot of the times the guy's just guilty, and it's really hard for me to argue the other side. I do what I can, but it's hard for me to argue the other side. This case for me is so difficult because I can't stand the guy. He's a total creep. He is after young girls. There is nothing likable about this guy. And I do have him completely guilty on the other sexting counts, and hopefully on those other 8 charges that he was indicted for. So I don't like him. There's nothing about him that's likable, nothing. But I have a really hard time with that he intentionally killed his son this way. So I am wanting the state to prove it to me. And I'm trying really hard to keep an open mind both ways. I really think this jury is going to be hung on count 1. I do not think they're going to get 12 unanimous. Now, things could change and the trial isn't over, but I'm just saying as of today, this is what I think, as of today, right now. But I don't know. And you know what? Do I care if the guy's locked up for good? Not really. Personally, I don't care because he's a total creep. And if he's out, he's probably going to be after girls again. So I don't care. Legally, I care. So that's how I go in, and I'm covering this trial. Now, what I want to say too is I want to thank Phil, because I'm going to end with his comments, but I want to thank him so much for this. Wow. I'm watching the chat room that's going on next to our YouTube feed, and they are just loving this. They have loved this last hour and a half, and we don't get this. We don't get this with every trial we watch. So I'm so thankful to Phil Holloway. Please follow him on Twitter at Phil Holloway ESQ, and find his Facebook page and like it. I will also put that in the comments of this video afterwards. He's a great resource on all cases, really. He does have a practice he's running, so he can't follow them all like he's followed this one, but he's heavily involved in this one because he lives right there and he knows all of the parties that are trying this case and defending this case. So I'm grateful for Phil. And now I'm going to put it over to you, Phil, and you take us out for whatever you want us to know about this case.
Well, first off, thank you for those kind words. I appreciate it. You know, I want people to look at criminal cases the way that you said. I want people to understand that our Constitution requires a fair trial, even for people who are pariahs, if Ross Harris is one. And it's a good case that's been made that he's a pariah. But the Constitution requires proof beyond a reasonable doubt. That's the highest burden known to our legal system, and the prosecution ought to be held to that standard in every case. When I was a prosecutor, I fully acknowledged it. I embraced it. I knew that was what the law was, and we did our best to meet that when we could. If we couldn't meet it, we couldn't meet it. But the jury will be the judge of that. Now, I'm going to withhold my decision about guilt or innocence until I've heard it all, because I really get the sense that there's more to come from the prosecution. We're not at the end of the state's case yet. Has the defense done a good job at pointing or poking a few holes? Yeah, they've poked some holes. They've raised some issues. Whether or not those issues amount to reasonable doubt is a question that remains to be seen. Once the prosecution rests, the defense then starts putting on evidence. And we're going to hear from other expert witnesses about how plausible it very well could be that despite all the coincidences, this could just have been just an accident, something he just simply forgot. So I want to encourage everyone to keep an open mind, because that's what I'm trying to do. I do believe, if I had to vote today, that if I were on the jury, I would say they've proven their case on the sexting charges at a minimum. And they may have crossed the threshold on criminal negligence. But as Mr. Boring said in his opening statement, it's all about malice, and we're not finished hearing the state's evidence yet. And we haven't heard the first bit of the defense case, and we know they're going to put up a case. I have the advantage that many people don't have, that I know these lawyers very well. I've tried cases with many of them, against them. I call them all my friends, and I can tell you, Chuck Boring, for example, handed me one of the worst defeats of my professional career, because he was so very well prepared, and prepared for things I didn't think he was going to be prepared for. So I'm not going to underestimate the prosecution team, and I know that the defense team, if I know them the way that I think they do, they are very well prepared. They probably have a few tricks up their sleeve that we don't know about yet either. So it's all going to depend on proof beyond a reasonable doubt, not just whether or not we like Ross Harris or we think he's a crappy person. They've proved that much. I'll concede that they've caused everybody who's watched this trial to really, really dislike the guy. But if you can step back from your dislike and consider the law and consider proof beyond a reasonable doubt, then the defense has a fighting chance of prevailing, at least on the issue of malice, perhaps even on the issue of criminal negligence. They may very well have conceded the sexting as a practical matter, but again, that's a much less severe sentence. It's a reasonable trial strategy. So with that, I'm just going to say, no pun intended, but the jury's out. We got to hear it all. We've got to hear everything.
That's right. Thank you so much. And I think you and I will plan another show before this trial is over. And maybe during the defense case, that'll be a good time to do it. Thank you, Phil.
No doubt. Good night, everybody.